Protecting Whistleblowers from Employer Retaliation by Amanda Stewart at Appalachian State University, December 3, 2015. Who are whistleblowers? A whistleblower is a person who exposes any kind of information or activity that is deemed illegal, dishonest, or not correct within an organization that is either private or public. The two classifications of whistleblowing are private and public. The classifications relate to the type of organization someone chooses to whistleblow on, private sector or public sector. Both can have different results that depend on many factors. However, whistleblowing in the public sector organization is more likely to result in federal felony charges and jail time. A whistleblower who chooses to accuse a private sector organization or agency is more likely to face termination and legal and civil charges. Whistleblowers play a key role in the work environment, and the information that they give is vital for putting an end to unethical practices in the workplace. Much unethical behavior is uncovered due to whistleblowers. Unfortunately, many people see the whistleblower as a snitch or a lowlife who betrays a sacred trust largely for personal gain. What can happen when you blow the whistle? It is not an issue that can be ignored, due to the possible negative consequences for both your employees and your organization. For example, a recent review of whistleblowing incidents shows that among the whistleblowers surveyed, 62% lost their jobs, 18% felt that they were harassed or transferred, and 11% had their job responsibilities or salaries reduced. 51% of the incidents resulted in external investigations of the companies involved, 37% in management shakeups, 22% in criminal investigations, and 11% in indictments. So, aren't there laws in place to protect whistleblowers? In 1989, President Bush signed a Federal Whistleblowers Protection Act, which extends protection available to federal employees who disclose government waste, fraud, and abuse. This law does not directly affect private sector employees. However, numerous legal scholars have recommended comprehensive federal legislation protecting both public and private sector employees. Legal protection can also be granted to protect whistleblowers, but that protection is subject to many stipulations. Hundreds of laws grant protection to whistleblowers, but stipulations can easily cloud that protection and leave the whistleblowers vulnerable to retaliation and legal trouble. Trending in whistleblowing. The Occupational Safety and Health Administration is seeking comments on a draft document intended to help employees develop a program to protect employees from retaliation when they raise concerns about the workplace conditions or activities that could harm workers or members of the public. The document is also intended to create a safer environment for those who whistleblow. OSHA will be accepting comments until January 19, 2016. Pound, who led a World Anti-Doping Agency independent, uncovered widespread doping around corruption in Russia athletics with the help of evidence provided by middle-distance runner Yulia Stepanova and her husband Vitaly, a former Russian anti-doping agency official. Pound says that there must be more done to protect whistleblowers who are often treated worse than the drug cheats that they help expose. He goes on to say, "We actually don't do whistleblowing reporting very well. We need to improve that. Clearly we have evidence whistleblowers can be an important part of the exercise. We have to work out what our policy is and how we do it." So OSHA's Whistleblower Protection Guidelines. OSHA creating whistleblower protection guidelines is extremely important. What is even better is that they are accepting comments from the public. This way, everyone has a chance to give their input on whistleblower protection. OSHA creating these guidelines shows that although there are laws to protect whistleblowers, they recognize that proper procedure is still not in place to ensure their safety. OSHA currently has provisions in place to help protect whistleblowers. If employees experience retaliation, they are to file a complaint with OSHA. Amongst the statutes in place for whistleblower protection, there are two that stand out the most. These are the Occupational Safety and Health Act and the Sarbanes-Oxley Act. The Occupational Safety and Health Act prohibits any person from discharging or in any manner retaliating against any employee because the employee has complained about unsafe or unhealthful conditions or exercised other rights under the Act. The Sarbanes-Oxley Act protects employees who report fraudulent activities and violations of Securities Exchange Commission rules that can harm investors in publicly traded companies. The wrongdoing, scandals, and resultant publicity, and the anger brought on by the leaders of failed corporations such as Enron and WorldCom were the moving forces for the law. However, there is much controversy about this statute. So what are scholars saying? The language of the Sarbanes-Oxley Act leaves no doubt that Congress intended whistleblowing to be an integral part of its enforcement mechanism. Unfortunately, the provisions give the illusion of protection for whistleblowers without effectively providing it. There is increasing evidence that virtually no whistleblower who has suffered retaliation and pursued remedies under Sarbanes-Oxley has been successful. Dworkin says that, despite the intended promotion and use of whistleblowing to help enforce Sarbanes-Oxley and deter wrongdoing in the securities market, the statutory scheme gives the illusion of protection without truly meaningful opportunities. Dworkin goes on to say that, in enacting the Sarbanes-Oxley Act, Congress ignored the overwhelming evidence that merely protecting whistleblowers from retaliation or giving them a cause of action is unlikely to spur whistleblowing. It has also ignored the evidence that significant rewards are an effective spur. Dworkin believes that the Sarbanes-Oxley Act should be reformed to implement a reward system. Dworkin says, observers of wrongdoing should be allowed to bring a sealed claim to court, and if the information is novel and leads to a successful case, the reporter should receive. Dworkin and Neer say that the statutory approaches toward whistleblowing currently appear to be based on the assumption that most observers of wrongdoing will report it unless deterred from doing so by the fear of retaliation. Dworkin and Neer disagree with this. Neer states, our review of research from studies of whistleblowing behavior suggests that this assumption is unwarranted. Dworkin and Neer believe that there is a better approach to whistleblowing. Previously, I discussed Dworkin's dissent with some of the Sarbanes-Oxley provisions. Dworkin believes that an alternative approach with better provisions can provide the protection that whistleblowers need and deserve. The encouragement of valid whistleblowing is essential to this approach, says Neer. Currently, internal reporting is valid, but only if it is to an official that is capable of doing something about the report. External reporting is generally a hazardous act, such as reporting to the media. All reporting should be considered valid and acceptable. Dworkin and Neer believe that increasing self-monitoring of ethical behavior can stop many of the problems we see with whistleblowing before they begin. If organizations make sure that ethical behavior is a top priority, leaders will be less willing to commit unethical acts, thus leading to declining reports of unethical behavior. Too many loopholes are given for employees that retaliate against whistleblowers. While laws seem as though they provide adequate protection, they do not. If that were the case, so many cases would not be dismissed or withdrawn. While whistleblower reports suspicious activity on the basis of morality, it may not be worth it for them to lose their job. Rewards must be given to whistleblowers for having the courage to speak up about unethical activity, even if it jeopardizes their career. I agree that implementing a reward system would give much incentive to observers to blow the whistle. It is clear that there are actions that can be taken in order to help protect whistleblowers. Laws have already been passed to protect whistleblowers, but as time goes on, I believe these laws should be changed. More discrepancies are being discovered with these existing laws, so these laws should not be final and should be amended. So what have we learned? Let's look at the main points. Whistleblowers are vital for putting a stop to unethical behavior. Employer retaliation against whistleblowers is unacceptable and must be put to an end. Whistleblower protection statutes are inadequate and provisions must be made, and whistleblowers need better reporting procedures in the workplace. Thank you.